Okay, John, are you ready on your end?
Ready? Yeah.
Yep. Okay, we're ready.
Good morning. For those of you watching the live stream on YouTube, this is the final 2 days of argument for spring 2021. Welcome. We trust that in September, when we see you again, we will all be together in one of our courtrooms. I think in September we'll be in our Harrisburg courtroom. Brian, why don't you call the first case for us?
The first matter is Wanda Brooks versus the Family Court of the First Judicial District. Representing appellant is Miss Megan Davis. Representing Wanda Brooks is Mr. Jerry Lyons.
We granted allowance of appeal in this matter to consider whether the trial court denying summary judgment sought by a governmental entity claiming sovereign immunity constitutes an immediately appealable claim. You can get the essence of your argument out before we begin interrupting. Please proceed.
Thank you and good morning. As you mentioned, my name is Megan Davis and I represent the appellant, the Family Court of the Court of Common Pleas of the First Judicial District in this matter. You accurately summarized here the issue in this case, whether under Rule 313, the denial of a motion for summary judgment based off of an absolute immunity defense qualifies as a collateral order under Rule 313, and more specifically, whether the Commonwealth Court here erred in holding that Family Court would not suffer any sort of irreparable harm if forced to proceed to trial before receiving appellate review of the merits of their claim. As we cite in our brief, the Commonwealth Court's holding in this matter is in direct contradiction with a clear legislative mandate that says that sovereign immunity is immunity from suit and not simply immunity from damages. And further is contrary to this court's holding in the Pridgeon case that held that the costs associated with proceeding through trial do in fact constitute an irreparable harm when we're dealing with a case where a defendant is presenting a substantial claim of immunity. But in these 2 minutes, I would like to draw this court's attention to this court's statement in the case of Genevieve versus Frisk. And in that case, this court held that when analyzing claims under Rule 313, claims must be analyzed not with respect to the specific facts of the case, but in the context of the broad public policy interests that they implicate. The question before the court today is one that goes beyond the narrow scope of this litigation. The issues here cannot be considered in a vacuum. We have to consider the far-reaching effects of the harms that the Commonwealth Court's holding presents, along with the public policy considerations underlying sovereign immunity's protections and the harms that it's meant to prevent, such as the waste of taxpayer funds in litigating cases for which a Commonwealth entity is ultimately immune, distracting public servants from their duties in order to work with counsel to defend a case, answer discovery, appear at depositions and trial, all of those burdens that accompany being a litigant in a case, and deterring qualified individuals from participating in public service for fear that their decisions will be subject to questioning at trial. These are all harms that sovereign immunity is meant to prevent, and they're harms that cannot be adequately vindicated once a trial has ultimately occurred. And so keeping these considerations in mind, it's clear that the Commonwealth Court's holding in this matter was ultimately incorrect, and that Family Court would indeed suffer an irreparable harm if forced to proceed to trial. And with that, I believe I'm coming up on my 2 minutes, so I will open it up to questioning.
Any questions from any justices?
Counsel, it's Justice Donahue. Is this your first argument before our court?
It is, yes.
Well, welcome to our court.
Thank you.
You agree, I assume, with the Commonwealth Court holdings on the first 2 prongs of the test for whether or not it's an appealable collateral order. Is that correct?
That's correct.
And Ms. Davis, why do you take such offense at the trial court observation that while it would be some hassle to go through discovery and pleading in trial, you're right to immunity is not irreparable loss unless some fact would come out that at least I don't see. You can claim immunity as an affirmative defense, and you can raise it at any point. So you haven't lost it. It's not like a privilege where or the disclosure of identity of source, where once it's out there, it's out there.
That's true, but that goes back to the policy considerations that I just mentioned. Here, we're talking about the exposure to litigation here is the harm. When an official has to sit on the stand and defend the actions of their employer, that is a harm in and of itself. So by saying that there is no irreparable harm by forcing the court to go to trial, a Commonwealth court and the trial court below ultimately misunderstood the reasoning behind sovereign immunity.
The statutory basis upon which you rely, one, Pennsylvania Consolidated Statutes 2310, speaks to sovereign and official immunity. What do we do with the case? Because we write not for your case, but to develop Pennsylvania law, where the contention of the official is that he's acting within his official capacity. Therefore, this would kick in, and presumably, if you prevail in this case, the opinion that we issue would allow him to or her to have the case dismissed at this juncture. But the opposing counsel argues that they were acting in an individual rather than official capacity. In that case, do we wait till trial's over? Do we do some sort of special proceeding before we go forward?
It would depend on the nature of the immunity. Official immunity or official capacity claims, obviously the official is acting on behalf. Sorry, I believe I saw you speak, but didn't hear you.
No. What did I hit?
Apologies. So as I was saying, it would depend on the nature of the immunity. An official capacity claim would obviously fall underneath the umbrella that we're talking about here. An individual capacity claim, it would depend on whether the individual's immunity is an absolute immunity or some sort of qualified immunity that could be subject to some sort of factual prerequisite. Here, official immunity, if we're talking about it in the context of sovereign immunity, would be an absolute immunity. So that would be something that would also come up on collateral review.
Thank you, and I apologize. I hit the wrong button on my computer and my screen went blank for a minute, but our technical people fixed it for me.
Ms. Davis, Justice Todd, you may have presented us with the only case I can recall where amicus briefs have been filed by the General Assembly, the Governor, and the Attorney General, all taking the same position in your favor.
Yes, an unusual case to be sure.
Well, hearing no further questions from anyone, any justices have anything? Presented your case very well. We'll hear from opposing counsel.
Thank you.
Justices, I'm Jerry Lyons. I'm for Wanda Brooks. I make a strong dispute with family court and all the amicus briefs. I didn't sue any official. I didn't sue any one person. No public official or employee is at risk here. I sued family court. They all gripe about public officials spending money, human resources. I did not sue one human being. I sued family court. They say sovereign immunity is too important. It will be unprotected without immediate appeal. What about the exceptions? Keep in mind, this is a governors. They talk about local government units. This isn't the Political Subdivisions Tort Claims Act. This is sovereign immunity for a state government building. Family court, their rights can still be vindicated. Let's go to trial and see. For all I know, it's going to be a defense verdict and this whole appeal is going to be moot. Governor Wolf, the Attorney General, the General Assembly, they're talking about speech and debate immunity clauses, presidential immunity, civil rights cases. That's not this case. This case is a garden variety tort case under the real estate exception to sovereign immunity.
Counsel, I think you got your 2 minutes in. Let me ask you, don't we, under our precedents and indeed under the statute 2310, first need to determine the sovereign immunity question before we would look at any exceptions?
I don't think so in this case, because that was never disputed. I listed the real estate exception in my complaint. Their answer addressed that. No one raised sovereign immunity in preliminary objections. If it was
telling us there's a waiver, are you trying to tell us that this legal question is not properly before us, counsel?
Absolutely, because if it was so important, family court would have raised it in preliminary objections. Family court would have filed a motion for judgment on the pleadings. They waited to go through pleadings. They waited to go through discovery. We're on the eve of trial. And then all of a sudden, they raised this issue. My mother always told me if it was so important, you would have done it first thing. Well, if this issue was really so important to them, they would have filed POs. A lot of these cases that the courts have issued were raised via preliminary objections, not on the eve of trial via a summary judgment. Believe it or not, they did file POs. Family court filed POs because they claimed I misidentified the address. I didn't have the right address of the family court building.
Just a brief
So
follow-up.
important. They would have filed POs on sovereign immunity.
Can I just briefly follow up, counsel? You emphasize that the rules encourage parties to raise immunity early in the proceedings. That seems to be the thrust or part of the thrust of what you're arguing. Doesn't, to the extent that's correct, doesn't that in and of itself signal the emphasis that this question of immunity from suit is designed to prevent suit, not just to prevent judgment or to deal with liability issues? Do you see my point? In other words, in a backhanded way, isn't your argument just giving emphasis to the point that this is a threshold issue? This question of law, if you're what I'm taking now to be a waiver argument, which I'm not sure is preserved, but supposing you don't prevail on this waiver argument you're making today, aren't we right back to this threshold legal question that the rules you invoke themselves underscore?
I don't necessarily agree with that, because that means that every time there is a challenge to a sovereign immunity case under any exception, which is undisputed, you're going to have an immediate appeal. It's going to open a floodgate of appeals. Every time there's a sovereign immunity issue, the Commonwealth is going to scream immediate appeal, even when it comes under the real estate exception or any other exception. And I want to make comment, Justice Saylor, when you wrote the Pritikin opinion, that wasn't based on state law. You were specifically applying federal statute, the General Aviation and Revitalization Act. There was a federal policy. You even cite that in your opinion, and I'm looking at the 905 Atlantic 2nd. It's at the bottom of page 433. You say Congress was concerned with exposure of covered aviation manufacturers to both liability and damages and associated litigation costs. And you talk about the clear federal policy to contain costs under that statute. This case is a garden variety tort case. We're not talking about any federal statute or civil rights case. Nobody's life or liberty is at issue here. We're talking about money. They don't want to spend the money. Money. It's like that song from the movie cabaret. Your honors, are you going to allow immediate appeal every time a government entity screams money, money? It's going to cost us money. And keep in mind that family court didn't spend anything because attorney Josh Feisner, who was counsel for the city of Philadelphia, he did double duty. He enters his appearance for the family court in this case. Family court didn't send their own lawyer to all the depths and the expert depth and all the pre-trial matters.
Let me follow up then. You keep raising these case-specific considerations, that this is the family court and they hire the state's lawyer, which seems to be in tension with your argument that this isn't the state somehow. But then you're arguing that this is a garden variety tort case, and I'm struggling to understand what legal standard you want us to adopt. Are you telling us that we're supposed to instruct trial courts to ask if it's a garden variety tort case as opposed to a multi-million-dollar case, or I guess I'm struggling with how you want us to address a question of law through the prism of these case-specific considerations you're arguing today.
What I would like you to do is say, yes, Commonwealth Court did the right thing by sending this back to the trial court for a decision on in front of a jury, that they accurately applied the rules, that they accurately applied the collateral order rule of 313, and that they found that there was no irreparable harm, because under Pennsylvania law, just because you're spending money, that's not irreparable harm. You must have more than just a money argument. And that's all the family court and the amicus briefs claim. It's all money. And I think what
understand. Can I just get back to your more case-specific argument? We understand that you don't like the idea that it's about not spending money. Let's get back to your argument on that sounds a little bit like waiver. First of all, was sovereign immunity raised as an affirmative defense in new matter?
Justice Donahue, I just want to clarify. I concede that sovereign immunity is not waivable. I mean, that's the case law.
Okay, so let's get to the basis for the decision of the Commonwealth Court. The argument that the family court is making is that this immunity is an immunization from suit, not only damages. If I'm maybe channeling your argument into their assertion, they have already voluntarily participated in this suit for an extended period of time. So any claim that the immunity from participation in suit is in danger here should fall on deaf ears, because they have already participated in discovery in this matter and through the pleading stage, including filing a motion for summary judgment. So at least as to this case, maybe your argument is this isn't the best case to decide this issue, since they have in fact already voluntarily participated in suit instead of raising the issue at the earliest opportunity. Is that what you're telling us?
Yes, I am. And this is not the test case for them, because they've gone too far.
That's a different argument than in no case can the question of absolute immunity be decided on the basis of a collateral order. You're just saying this case isn't the case to decide that issue.
Correct. In all their briefs, no one mentions the real estate exception. They're all...
Counsel, it's really not the real estate exception. It doesn't matter. There's a much broader principle involved here than the nuances of the Sovereign Immunity Act. I mean, and I think that's where you're sort of, getting off track on what might be a solid argument that they have, to the extent that this was intended to be an immunity against suit. This Commonwealth agency has voluntarily participated in suit for too long to raise that as a predicate for deciding this as a collateral order.
I agree with that.
Mr. Lyon, who owns this?
And if this court allows this
Mr. Davis,
immediate appeal in this case, every time sovereign immunity is raised, you're going to have the same thing. You're going to have a floodgate of appeals just because someone's griping sovereign immunity.
Mr. Lyons, may I interrupt you? Justice Saylor has a question for you.
Yeah, Mr. Lyon.
You should answer these questions.
Thank you, Chief. Mr. Lyon, who owns this building?
I'm sorry?
Who owns the building?
The building, if I recall correctly, is owned by the city of Philadelphia, and it was leased to Family Court. Family Court maintained it. They provided security. The Family Court was even involved in the design of the building. Originally, I sued the architect as well, and we settled with them and got them out of the case. But Family Court leased the building. It was a very extensive lease. They maintained the building. They provided security, and like I said, they were involved in part in the design of the building. In fact, the part of the building that caused this injury, it was an unmarked glass wall. They specifically decided after this incident to put markings on the glass wall. They decided to add some stripes to the glass wall so people would see it. They had in that regard, they had dominion and control over the building because the architect suggested it, but they had to get final approval from Family Court to actually change the glass walls.
All right. Mr. Lyons, just really, really briefly back to what I think is an incorrect argument, respectfully, regarding when immunity should be raised. You answered Justice Donahue that immunity is specifically raised in Rule 1030, affirmative defenses, which are part of an answer, which come after preliminary objection. Do you agree with that as a matter of law? Not a matter of policy. Whoever wrote the rules, that's where they put immunity.
I agree with that. The rule says what the rule says. I don't dispute that, Your Honor.
So if the opposing side in this matter had raised immunity as a preliminary objection, you could have argued that that's premature pursuant to the rules, could you not?
I wouldn't have argued it because case law is very clear that immunity can be raised via preliminary objection. It's clear they raise it there. My gripe about that is now they're coming before the Supreme Court and saying this is the most important issue. This is a groundbreaking issue. Well, if it would, their actions, their inaction to raise it in preliminary objection shows it's not all that important to them.
But that's not waiver. You're complaining about their litigation strategy. They raised it when the rules told them to raise it.
All I'm saying is that their actions are not consistent with what they're arguing now, that this is the most important thing.
For what it's worth, it used to be that if you tried, I'm old, if you tried to raise immunity and preliminary objections, it was dismissed. And then the Commonwealth Court, and I'm probably talking 25 years ago, said if the immunity question can be decided as a matter of law with no facts whatsoever, we'll hear it on preliminary objections, notwithstanding the rules. So it's sort of an exception to the exception, but that's okay. I understand your answer. Questions from anyone?
Chief, I want to follow up on what counsel was just saying, if I may. You continue to argue something that sort of looks and sounds like waiver, but you don't get waiver here. So I don't know if you're kind of trying to dirty them up with some kind of estoppel type of claim. That's not in your papers. And it keeps bringing me back to the question, isn't this a pure question of law before us? presumably, there's a question of law before us. We granted aliquotter here. And I haven't really heard you offer us an argument of law why, notwithstanding the Cohen case in SCOTUS and our Pridgeon case, immunity is something other than immunity from suit. I mean, doesn't 2310 talk about immunity from suit? And don't the cases talk about immunity from suit rather than immunity from damages or immunity from liability? How are you going to get over that hill, presuming, we don't toss the case like I guess you're kind of asking us to do on some sort of quasi-waiver, quasi-estoppel point of view?
I think before you get to that, Justice Weck, you have to say, did Commonwealth Court appropriately apply Rule 313? The only reason this case went back to the trial court was because the Commonwealth Court said money alone is not irreparable harm. And I think before you get to all these legal issues, you have to say this, the Supreme Court has to say, did Commonwealth Court rightly decide that spending money is not irreparable harm? That, I think, is the issue. I understand all the immunity arguments, but I think before that, you have the procedural rule, and the procedural rule is, does Rule 313, one part of it, irreparable harm, does spending money constitute irreparable harm? If you find in favor of family court, you'll say yes. If you find in favor of Wanda Brooks, you'll say no. I think that's the decision, justices, that you all have to make. And if you say, my argument is, if you decide that spending money constitutes irreparable harm, then I think you're going to open up a floodgate of litigation every time there's a sovereign immunity argument. I think it's procedural. I understand. I think I understand what you're saying, but I think this case is extremely focused in the Commonwealth Court decisions. The Commonwealth Court outlines those three elements of Rule 313, the collateral order rule, very methodically, and they got down to a simple decision. Spending money is not irreparable harm. And Justice Saylor, in your Pridgeon case, you were out there in federal statute, in federal law, regarding federal Congress and what they thought the federal policy was to contain costs. That was not state law as decided, as our state precedent holds, as the Commonwealth Court held. So I think this is pretty straightforward under a procedural issue, with all due respect.
Any other questions from anyone? Thank you very much, Mr. Lyons. The case will be accepted and we'll get you a decision in due course. We're going to take about a 5-minute break. We have a few technical glitches that our technical people want to work out before we start the second case. A 5-minute break between cases. Thank you.
Thank you.
So the next argument is Commonwealth of Pennsylvania versus Robert Paul Brozenick. Representing Mr. Brozenick is Mr. Brandon Ging. Representing the Commonwealth is Miss Margaret Ivory.
The appellant in this case was charged with 5 counts each of terroristic threats and simple assault for pointing a gun at 4 juveniles and 1 adult victim. At appellant's trial before the Commonwealth rested its case, only 2 of the victims testified, indicating that they felt threatened by appellant's behavior. After the Commonwealth rested its case, appellant's counsel made a motion for acquittal regarding the 3 victims who did not testify, arguing that there was insufficient evidence presented regarding their state of minds to convict appellant of the crimes of terroristic threat. The trial court initially indicated he was going to grant the judgment of acquittal, but asked the Commonwealth if it wanted to move to open its case to present more witnesses. Upon indicating that it did, the court permitted the Commonwealth to proceed with the testimony of 2 more of the victims. Eventually, appellant was convicted of the charges against the 4 victims who testified, and the Superior Court affirmed. Appellant now argues that the trial court abused its discretion in allowing the Commonwealth to reopen the record and present additional evidence when at the time it rested, it had arguably failed to present sufficient evidence in its case in chief. Mr. Ging, feel free to proceed.
Thank you, Your Honor. Good morning, and may it please the court and Ms. Ivory. My name is Brandon Ging. I'm from the Allegheny County Public Defender's Office, and I represent Mr. Brozenick. I'm honored to be here this morning. As you indicated, the issue here is whether the trial court erred in reopening the record at the Commonwealth's request. I believe you can kind of pare that down a little bit to 2 important themes, and that is what impact or teeth, if any, does Rule of Criminal Procedure 606A1 and 2 have on a trial court's decision in that regard? And secondly, what is meant by preventing a miscarriage of justice, as that seems to be the defining standard right now in Pennsylvania. The Superior Court held that based on Commonwealth versus Tharp, the trial court did not abuse its discretion. It's our viewpoint that that case is manifestly distinguishable. And secondly, that neither the Superior Court nor the trial court considered the case of Commonwealth versus Baldwin, a case by this honorable court. And it's our position that had either court done that and applied the standard that's set forth there, it would have been impossible to conclude that it was appropriate to reopen the record in this case. I'll begin with the Tharp case because that's where the Superior Court landed. Factually, that individual was charged, the defendant in that matter was charged with corruption of minors. And that's a crime that requires proof that the defendant at the time of the crime was over the age of 18. The defendant was 31 at the time of trial. So as he's sitting there in the jury trial, the jury could obviously view him and probably reasonably conclude he was over the age of 18. The prosecutor introduced no direct evidence of his age. Defendant moved for a judgment of acquittal, arguing there was insufficient evidence of his age. The trial court did not make a ruling on the motion for judgment of acquittal and allowed the Commonwealth to introduce evidence regarding his age. And this honorable court found that that was not error. It distinguished the Commonwealth versus Zoller case because in that matter, the trial court had not yet made a ruling on the motion for judgment of acquittal. But I think what is more pivotal about that case, it said that under the unique circumstances that it was understandable why the prosecutor took the position that he did. Again, the jury is sitting there. They have the opportunity to see the defendant. They could probably reasonably conclude that he was over the age of 18. And under those circumstances, it was appropriate for the trial court to reopen the record. But our case is very different from that one. In this case, the trial court, as Chief Justice Baer indicated in his summation, the trial court did indicate that he was going to grant the motion for judgment of acquittal. The Commonwealth had not yet moved to reopen the record yet, and it was only after the trial court began its explanation as to why it was going to grant that motion did the Commonwealth finally say, okay, give us an opportunity to put on the additional evidence.
Mr. Ging, Justice Todd, I had a question about Tharp.
Sure.
Doesn't it seem to you that one of the fundamental differences between this case and Tharp is that in this case, there might be a dispute as to what the testimony was going to be. There might be some ambiguity. There might be some cross-examination that could destroy that testimony. It wasn't a fact that was being introduced. It was how the co-defendants reacted. What happened in Thorpe could be demonstrated by simply looking at the driver's license. It's a fact that's indisputable. So to me, they're two very different cases for that reason as well.
I don't disagree with you. Ultimately, I do think the trial court, if you read the record, I think he was correct in indicating that there was not circumstantial evidence with regard to the elements in question. One of the witnesses testified that, quote, he, meaning my client, did say something, but I do not remember what he said. It happened so long ago, it's not refreshing my memory as to what he said. The other witness testified that all he could recall Mr. Brozenick saying was, quote, leave or I'll call the police. So there wasn't any sort of evidence with respect to the threats or whatnot.
I meant to say the witnesses, not the defendants, what the
Sure.
witnesses would say, yes.
But to me, maybe the most pivotal aspect of the Thorpe case was that what makes this case different is the prosecutor made the informed decision not to put the additional witnesses on the stand. They were there. There was 4 of the 5 complainants were in the courthouse. He decided to put 2 on the stand, and he rested his case. When defense counsel made his motion for judgment of acquittal, the prosecutor responded and said he was satisfied with his presentation of the evidence. The other witnesses were there, but he didn't believe their testimony was appropriate, that it was necessary, that he met his burden. Ultimately, whether or not the trial court was correct in indicating that it was going to grant the motion for judgment of acquittal, the prosecutor had those witnesses available. Why he chose not to put them on, I'll never know.
Mr. Gang, could I ask a question, please?
Yes.
Taylor. But here's the problem. I don't think there's any question that the trial judge is wrong. And that's the difficulty in this case, because there's no principle of law of which I'm aware requiring the Commonwealth to present the testimony of each victim of an assault occurring during a single criminal episode. So that's what started the problem. The evidence under any principle of law, which I'm aware, was not insufficient.
I don't disagree with your interpretation, Your Honor, but at the end of the day,
once the trial judge starts down the wrong path, even if he would have granted the motion for judgment of acquittal, that would have been different. Then the Commonwealth would have been put to a decision. But when he says on the record this evidence is insufficient, when, as you agree, it's clearly not, that creates a very difficult case for the Commonwealth.
I don't disagree with your position that victims are required to testify. I don't disagree with that. But I actually think the trial court was correct that there was not circumstantial evidence as to any of the victims.
That's different. He said you only grant this if there's an evidentiary insufficiency. And there's not. You don't have to, as I said, and I'm repeating myself, and you agree, call everything when it's a single criminal episode.
I ultimately, and I hope I addressed your question adequately.
You did very candidly and fairly. Thank
you. The issue today isn't whether the trial court, would have correctly ruled on the motion for judgment of acquittal. The question before this court is, was it appropriate to reopen the record when the Commonwealth made the informed decision not to put certain evidence into the record?
But a judge is saying that's insufficient. So the Commonwealth, what's the Commonwealth supposed to do? Say, thank you, we're going home? Or he ask to open the record and it's granted. Reopen.
So I guess in a lot of ways, this comes back to what I think some of those themes that I mentioned at the outset. Like, what is the value of a motion for judgment of acquittal if the defense is going to point out the Commonwealth's evidentiary shortcomings and the response is going to be, okay, Commonwealth, go ahead and fill those gaps?
Mr. Ging,
yes.
Chief Justice Baer, with greatest respect to my friend and colleague, Justice Todd, I think Thorpe is analogous. Litigation is not a game of gotcha. And there's several cases, but I just happened upon a quote from Thorpe. The introduction of direct evidence to avoid the possibility of a result inconsistent with the true facts should be allowed, which is my language, not their language. You were not prejudiced in any way, other than prevailing in the case, which is not legal prejudice, as you well know, by this momentary resting of the Commonwealth and reopening by the Commonwealth. Is that fair?
That's a tough one, Your Honor. Yes, I believe he was prejudiced. Ultimately, he was convicted. Had the Commonwealth not presented that additional evidence, it's fair to conclude the trial court would have followed through on its intent to grant the judgment of acquittal.
Yeah, but the problem, Mr. Ging, and we don't have to get into a long philosophical discussion about it, but that's not prejudice as the law understands it. If it was, everyone's prejudiced by anything adverse to them to the extent it contributes to a verdict against them. The question in these kinds of cases, in the cases where there's been a finding of abuse of discretion, is that witnesses have gone home. Witnesses have passed away. Evidence has been destroyed between the resting and the reopening so that you can't fairly rebut. And that's one genre of prejudice. Here, and I don't want to fight with you, but here, Commonwealth, within probably 3 minutes, Commonwealth closes, motion for acquittal made, trial judge says, hey, not good enough, Commonwealth reopens.
Mhm.
So it's really difficult, I think, to argue prejudice and want to say, well, sure, there's prejudice. Evidence went in against my client, but I don't think that counts as prejudice.
I guess reasonable minds can differ with respect to that, but that's why I think what's problematic is we have rules of procedure in place where the Commonwealth motions for judgment acquittal can be made at the close of the Commonwealth's case as well at the close of all the evidence. Defense counsel followed the rules and he made that motion, and everybody is experienced. I would venture to say that substantially more often than not, those types of motions are denied out of hand. But in this particular,
the rule that you're looking for, my last question.
yes,
The rule that you're looking for, because again, we write for the applicability of cases statewide for years to come, is when the Commonwealth rests, it cannot reopen. It better count its chickens prior to resting.
I don't know that I agree with that. I don't believe I'm asking for a per se or bright line rule in that regard. I think in the SAFCA case, Justice Donahue wrote a dissenting opinion, as did Justice Dougherty. And frankly, I think they nailed it. At the end of the day, the standard seems to be in the interest of justice or to preventing miscarriage of justice. But what does that mean? My interpretation of the case law seems to be, I guess the better way is to say the way Justice Donahue said it. It does not mean absence of conviction. I would venture to say that every defense attorney in Pennsylvania would probably interpret the word justice differently than every prosecutor in Pennsylvania. And it seems like the standard right now is interest of justice or preventing a miscarriage of justice is exactly what Justice Donahue said it is not, which is absence of conviction. And
Can
I
I
think that,
help in that, counsel?
I'm sorry. Yeah, but I didn't mean to interrupt. But again, to make my point, I agree with you that if the evidence would have been insufficient, it would have been reversible error to allow the Commonwealth to reopen the case, even though it would be an acquittal. Fair enough. You see my point?
I do
So I'm
see your
agreeing
point.
with you. You can't just let the Commonwealth reopen the case if they fail to introduce something.
I agree with you. I guess
Sufficient basis for the conviction. So I agree with you to that.
the only thing I would just add is I guess we disagree insofar as whether the evidence was in fact sufficient. I actually believe the trial court was correct. A fair and a very close reading of the record will show that the two witnesses that did testify didn't offer sufficient evidence with respect to them as well as with respect to the other victims. But the motion for judgment acquittal was limited to the non-testifying complainants.
Thank you.
Counsel, could I ask you a question? You asked for an interest of justice standard, and that partakes of a substantial helping of trial court discretion, I take it. In this case, you said that the prosecutor made an informed decision to rest, and I looked at the transcript here, and it read a lot like the trial judge walking a younger or less experienced prosecutor through this and sort of giving a hand, with no bad intentions. Just it read a lot like the kind of thing that I think happens every day in the trial courts, or if not every day, regularly. And I guess what I'm trying to understand is your the standard that you want us to articulate. I know you said interest of justice. Wouldn't the trial court here said it was just his discretion. He didn't really offer us a reason. But had he said, or were we to say that the trial court was doing this in the quote, in the interest of justice, how would he be wrong? Or is there some other standard that we should adopt? When they say the magic words, "we rest," are they done?
Not necessarily. Again, I don't believe I'm advocating for a bright line rule. I'm not going to suggest that there aren't extraordinary circumstances where a request to reopen the record after the Commonwealth rests would be inappropriate. I mean, just for the sake of discussion, what if these witnesses were not available? The prosecutor asked for a continuance, and the trial court said, no, today's trial, we got everybody else, so we're going to move to trial. So the Commonwealth puts on the evidence that it can, defense counsel moves for judgment of acquittal, and the prosecutor gets tapped at that point in time and says, hey, those witnesses just showed up. They're here. Under those circumstances, it might be preventing miscarriage of justice to not let the Commonwealth put those witnesses on. When it made an appropriate request to continue the matter, the trial court said no, and now that evidence is ready to be presented to the jury. But I think, I mean, what's the saying go? That you make your bed, you have to lie in it. The Commonwealth, for whatever reason, chose not to put these witnesses on the stand. You know, I can't get in the prosecutor's head why he chose not, why that was the strategy he chose. But then defense counsel basically caught him with his hand in the cookie jar and called him out for it. And the trial court, again, I believe it was the right ruling. Justice Sale respectfully disagrees with the trial court's reasoning on that. But he ultimately said, I'm going to grant the motion of judgment of acquittal. And as you said, Justice Wecht, then he began to walk the prosecutor down the path to get this evidence in. And I agree with you. I don't believe the trial court was acting with ill will here or anything along those lines. I don't know the prosecutor. I can say that defense counsel, who's a member of my office, this was his first jury trial. So I don't disagree with you that there were probably young prosecutors in this matter. But at the same time, it's game time. This isn't like, you know, mock trial. I mean, there's somebody's livelihood and interests at stake here. And it was only after the trial court began to explain to the prosecutor the shortcomings with his own case did the Commonwealth take that invitation and say, okay, well, then we'll reopen the record. Again, I think what the important thing is here is what I argued initially was if the factors set out in the Baldwin case would have been considered here, I personally believe it would have been very difficult to come back with the conclusion what the trial court did here was correct. Those factors are the timing of the request to reopen the record, the nature of the proffered testimony, and very critically, the reason for the party's failure to present the evidence in its case in chief. The prosecutor here, yes.
I'm sorry, Chief Justice Barr, and I think we understand, and you're drawing to the conclusion. You agree, do you agree with me that the legal issue is whether or not the trial court abused his discretion in reopening the record?
I do.
And you know the standard for abuse of discretion. It's not that if I was sitting on that trial court bench, I would have made a different decision. It's whether there's a clear error of law or a manifest impropriety in what the trial court did. Do you agree with that?
I do agree with that.
So you view, well, and you're an advocate for your side, but you have to make the argument that this is not just sort of poor judgment on the trial court's fault, but an egregious mistake.
I do, Your Honor. Just to piggyback on what you said about the abuse of discretion standard, discretion's abused when it's not exercised on a foundation of reason. And what is problematic here is the trial court at the time of trial, as well as in its 1925A opinion, offered no reasons for why it did what it did. And it's very difficult, I would imagine, as an appellate court to make a determination when the trial court is essentially silent with regard to that. As I indicated previously, I think I did at least, neither the trial court nor the Superior Court explained what miscarriage of justice was prevented here. And the only rational, logical conclusion that you can reach is it was to prevent the granting of a judgment of acquittal. But that's not a miscarriage of justice.
I have a question, if I may intercede.
Yes.
Suppose, Mr. Gink, that you have the defense in this case, and you have two witnesses that are imperatively important to a defense, to your client. And you put on your defense, but for whatever reason, you put on one witness, but not the other, thinking that your defense is sufficiently articulated. And you close your case. And then for whatever reason, it becomes very clear to you that you need the other witness to establish your defense sufficiently, legally sufficiently. Should the judge allow you to reopen your case?
I think if you'd have to review the factors in Baldwin to try to find out why wasn't this presented earlier, and if it was along the lines of what
Baldwin's
happened.
a little one-off because it's really a constitutional argument to some extent that a defendant has the right to testify. Isn't it? Isn't Baldwin a little bit distinguishable because of that factor in the case?
Yes, I guess I don't disagree with that. You know, the Tharp case was a Commonwealth request, and this court held that reopening record was okay. The Baldwin case was a defense request. In that case, the defendant had indicated he did not want, I believe he waived his right to a jury trial, and then he decided he wanted to have a jury trial and testify and offer his own testimony. The defense request was denied there, and the Supreme Court held that that was okay. And I think this kind of falls in line with my theme that interest of justice or preventing a miscarriage seems to be like, well, we're concerned about benefiting the Commonwealth here.
No, my point only, sir, is that sometimes I think that at least in my view, the interest of justice is really best delegated to the discretion of the trial judge because there are so many moving pieces and parts in a trial, and certainly we want to be fair to both sides. So that's all.
I agree with
Counsel,
you. Yes.
Counsel, Justice Donahue, just to clarify, Justice Wecht suggested that you were arguing for a test of the abuse of discretion based upon, in order to prevent a miscarriage of justice. That's not your argument. That's what we said in Tharp, is it not?
That's correct, Your Honor.
That is the standard that this court set in place in Tharp to determine whether or not there was an abuse of discretion.
It is, Your Honor. And what I find problematic about that particular standard is it seems to be undefined. And the case law seems to suggest strongly that it means, well, let's benefit the Commonwealth. I think that Justice Dougherty in his dissent in SAFTA set forth the appropriate test here, which is absent extraordinary circumstances. Again, that's case by case. I acknowledge that. Or an agreement of the parties. You know, trial courts should be very cautious about reopening the record. And I think that's even more so where the Commonwealth has rested, the defense has made its motion for judgment of acquittal. I personally don't think it's pivotal, but I think it weighs substantially in Mr. Brozenick's favor. The trial court here actually said he was going to grant the judgment of acquittal. But I don't think that whether the trial court tips his hand or doesn't is ultimately dispositive. I think the trial court should be very reluctant to reopen the record. Again, they have discretion, and I acknowledge there certainly can be circumstances where reopening record can be appropriate. I just don't think in this particular case there was any extraordinary. There certainly wasn't an agreement of the parties. And I think that it really sends a bad message that, you know, if the process, again, what's the purpose of defense moving for judgment of acquittal at the close of the Commonwealth's case or the close of all the evidence, if the response by the Commonwealth or the trial court is say, okay, thanks for pointing out the shortcomings in my case, let me fill those holes. Why would defense ever make that motion? I mean, I guess the better strategy is to just hope the jury gets it right, and maybe win on appeal. But that seems to be a waste of time and resources.
Can I follow up, Mr. Ging? As you'll recall, I was in dissent in SOFCA on the Superior Court. So when it came up to this court, I recused myself. If this court was not sufficiently troubled by SOFCA, where the not only had the parties rested, there had been closing arguments. The court took the matter under advisement, came back the next day, and offered a conclusion that more evidence was needed and allowed the EDR evidence to come in. What would you offer us as a reason why this case was more egregious than that? When what happened here is the judge, within moments, allowed the additional evidence.
As I read SAFCA, I mean, the issues there were, I think, substantially more complex. It was about the admissibility of that data evidence, what weight should be provided to it. You know, the trial court there said to both parties, I need to know more. I mean, that was a non-jury trial. This is a jury trial. I don't know if that's a distinction without a difference. But this case wasn't even, there was no complexity here. The Commonwealth made a decision to put certain evidence on the stand and not put certain evidence on the stand. In the SAFCA case, in as much as I think the trial court did abuse its discretion, not that that matters, my opinion on it doesn't matter so much, but at least gave both parties like an opportunity to weigh in on the matter. And I think that makes this substantially more different and more egregious because, as I indicated before, the trial court tipped his hand, told the Commonwealth, I'm granting motion judgment of acquittal, walked him down the path and to get the evidence in. Again, I don't think that was, you know, in bad faith or anything along those lines. But the SAFCA case, you know, you can kind of read that and say, well, it was somewhat of an issue of first impression. You had some complex issues there. The trial court was just trying to be thoughtful, gave both parties an opportunity to weigh in. That's not at all what happened here. And that's why I think this case is substantially tougher to swallow, because the Commonwealth, again, I don't want to beat it into the ground, but they made the decision not to put these witnesses on the stand. I'll never know why they chose to do that, but like I said before, you make your bed, you got to lie in it.
Thank you very much, sir. Well presented.
Thank you.
Ms. McGinley? I'm sorry, who? Ivory. Ms. Ivory, I apologize.
Thank you. May it please the court, my name is Margaret Ivory. I'm an assistant district attorney in Allegheny County. It's really the position of the Commonwealth that this case really comes down to whether the court was acting as an advocate and allowing, in the statements it made and allowing the record to be reopened. As this court knows, the court cannot act as an advocate, can't advance arguments on behalf of a party. It's our position that the court did not cross the line or venture into advocacy in this case during the sidebar discussion. The primary reason being that, as I point out in my brief and was noted in the Seabrook case, the court has a duty to control its courtroom and to ascertain the facts, and is not supposed to just sit by if they think pertinent information is missing. And as was already pointed out during this argument, the court also sometimes has to ask questions in order to get the information it wants, and maybe dealing with a newer attorney who is not as familiar with the format this court wanted to see in terms of the evidence as it was presented. And of course, the court was free to call witnesses. It was also free to question witnesses who'd been called, and it did neither in this case. As I said, it appears the court did not like the form of the evidence. It wanted to hear what the other witnesses had to say. As is noted in Tharp, and as I argue in my brief, that the court is faced with the motion. Excuse me.
Counsel, this is Justice Doherty. Let me begin by usurping or adopting the definition of the Chief Justice, his definition of abuse of discretion, for which is the focal point here. You cite Commonwealth versus Tharp. Now, interestingly, it seems most people concentrate on the sentence in order to prevent failure or miscarriage of justice. I kind of concentrate on the part right before it, prior to decision. Now, page 73 of the transcript, the Commonwealth at that point says, at this point, Your Honor, the Commonwealth rests. Why the defense attorney calls a sidebar is something I don't understand, as opposed to putting the motion for judgment of acquittal right on the record. He then makes a motion for judgment of acquittal. The DA at this point said that he made a strategic decision to present evidence, at which point he rests. It is at that point that the judge becomes somewhat of an advocate by prompting the Commonwealth, and so much so that he says at page 74, I am going to grant a judgment of acquittal on them. Bear with me, based upon the case that you cite, Tharp, how is that not a prior decision made in order to prevent failure or miscarriage of justice, coupled by the second question, what was the failure or miscarriage of justice? That the Commonwealth strategically failed to meet the elements of its offense or not? Such that, taken in a totality spectrum, viewing this evidence as a record is not blatant abuse of discretion by the trial judge.
Well, first, with regard to the motion, or to the statement about the motion, there had already been some discussion and some indication by the Commonwealth that they would call the witnesses. So he didn't just say he was going to grant the motion and then and then the Commonwealth then said, I'm going to call them. There was already the indication. However, with regard to Tharp, the real key is the reasonableness of the Commonwealth's or the prosecutor's failure to present the evidence in the first place.
Counsel, I don't mean to cut you off, but I apologize. I find you somewhat mischaracterizing the record. The record at page 73 indicates, Mr. Lorenz, Your Honor, at this point, the Commonwealth will rest. Mr. Tehovnik, if we can briefly approach. Yes, come up. I will make a motion for judgment of acquittal based upon the fact that the Commonwealth has alleged that my client threatened to call the police and brandished the firearm. The sufficiency. Here, the court says, what about the other victims? The Commonwealth says 2 of the other remaining 3 were present today. As a strategy and based upon discussions with them in the hallway, they are comfortable with the testimony as presented. The judge then prompts, how about their state of mind? The Commonwealth argues its position would be that their state of mind was that the defendants intended to threaten violence and make terroristic threats. Exactly the point what Justice Saylor discussed. The court, there were no statements made. Based upon the continual advocacy of the judge, the Commonwealth says, given the lack of testimony by these individuals, the defense says, we'll move for a judgment. The court, do you want to call them? It's up to you. I'm going to grant a judgment of acquittal. Share with me how that is not advocacy, better prosecutorial advocacy by the court than it is by the prosecutor. I'm somewhat astounded.
Well, it's our position that he may have gone up to the line in terms of what can be said. If this court finds that he went too far, I guess we'd ask for some guidance. He wanted the evidence in a different format than the prosecutor gave it. The prosecutor, as was discussed, not all victims have to testify. The prosecutor gave the reason for not presenting it.
So your position is that you agree the judge abused his discretion by
that's not.
No?
No, I believe hindsight is 20. Maybe he could have done it differently. If this court disagrees with it, then some guidance would be certainly useful. But
with respect to that guidance, counsel, thinking about Justice Dougherty's question, with respect to that guidance, wouldn't that proper guidance be that you trial judge, cannot coax or lever counsel to bring in new testimony once the Commonwealth is rested. In other words, it's one thing, counsel said, going back to Chief Justice Baer's gotcha question, it's one thing if the prosecutor says, and Your Honor, we rest, and then the prosecutor within moments says, oh my goodness, I forgot one thing, Your Honor, may we reopen? Okay, that's one category or species of cases. But here, as you saw from the colloquy Justice Doherty was questioning you about, you have a coaxing or a levering with no bad intentions. I think it's clearly an attempt to be helpful and guide a prosecutor. But it nonetheless is a coaxing or a levering. That point where that point where the trial court says, I am going to grant a judgment of acquittal on them. There's that lever, right? Isn't that a touch point for us to articulate as where the discretion is abused?
I understand the problems that the court has with the statements you made. I believe that based on his discretion to present a complete picture of the record, that saying that after the witnesses had already been discussed, the prosecutor made it clear they were readily available, and that he was willing to call them, and gave a reasonable reason why he hadn't called them. That in this particular case, it did not use its discretion, even though it made certain statements that it perhaps could have avoided and handled differently.
Counselor, Justice Donoghue, should we be following the guidance of Tharp and look for the question of whether or not the action by the trial court was taken in order to prevent a miscarriage of justice? And if we're looking for that, what was the miscarriage of justice here that the trial court was attempting to avoid?
Yes, I believe we should be following Tharp. Absolutely, it's the defining case on this subject. I think the court wanted the true facts, and in its mind, the testimony of the non-testifying witnesses' perception of the event was not established through the testimony of the two witnesses.
But counsel, if you could help me with that, in the context of a trial, are not the true facts only those facts that are in evidence?
Eventually, yes, but the court is judged is excuse me.
Not eventually, counsel. This prosecutor rested. The true facts that the prosecutor intended to place before the court were on the record. And that's why I struggle with, we've used that language. The Superior Court certainly used that language in this case. I mean, there are no true facts other than those that are put into evidence in a case. What the trial court may or may not want to have seen in the perfect case is just an entirely irrelevant consideration. The facts are the facts that have been put in evidence, in this case by the prosecutor. And this works on the other side also, for a defendant who decides that the case is done. I mean, the facts are what they are based upon the evidence that's been presented.
Correct, but the only reason anybody would ever reopen is because they perceive something is missing and there's some sort of gap. And as is said in Tharp and as in Seabrook, they has an obligation not to just let that go if they believe something is missing. That's where I guess the line.
So help me formulate your response to the question here. What was the miscarriage of justice that the trial court was avoiding in this case? That the prosecutor didn't establish the facts necessary for a conviction. Is that the miscarriage of justice that the trial court was trying to avoid?
Possibly with regard to two or excuse me, three of the victims.
And
No.
so miscarriage of justice would be that the Commonwealth would not get a conviction.
That the court would not know, that the jury would not know what happened, and it would not acquit or convict based on what happened and what the perception of those witnesses were. Those witnesses could very well testify to something different, and it could undermine the prior witness's testimony.
And it's fair to say, counsel, that it's the burden of the Commonwealth to prove those facts, correct?
Correct.
Not the judge.
Correct.
So
You
when
do
the
not-
judge intervenes on behalf of a party instead of being a referee, the judge becomes an advocate. That would be fair to say, would it not?
When he actually advances arguments, I agree with you, yes.
Okay, thank you.
Any further questions from anyone? All right, Ms. Ivory, thank you very much. Well presented.
Job well done.
Thank you.
We'll take another 5-minute break while we ask these counsel to leave, get new counsel in, and we'll come back in here for third case.
The next argument is JS versus Manheim Township School District. Representing the school district is Mr. Matthew Hennessy. Representing JS is Miss Lori McKinley.
For the benefit of the justices, we had a delay because one of our lawyers did not, we could not get her video to work. That's Ms. McKinley, who will argue for Aplt. She'll be arguing by cell phone, which we think will work, but just so everyone's aware. So we will be able to see her, but not hear her through her computer. This case involves the Manheim Township School District's expulsion of a high school student, JS, for making terroristic threats by sending memes to another student on a social media platform. And I should say alleged making terroristic threats in that manner. The media platform was Snapchat. The student was off campus and after school hours when the Snapchat was sent. The trial court reversed JS's expulsion from the high school, which the school board had made, on two grounds. First, the trial court held JS was denied due process at his expulsion hearing because he was not afforded the opportunity to question the student to whom he allegedly made the threat. The trial court found that while students have a right under regulations in the Pennsylvania Code to request that a witness appear in person and answer questions to be cross-examined, the General Assembly did not afford the student, the school district, or the administration the power to subpoena witnesses to testify at the expulsion hearing. Second, the trial court held that the school board's terroristic threat adjudication was not supported by substantial evidence. Engaging in a true threat analysis of the student's subjective intent in accord with this court's 2018 decision in Commonwealth versus Knox, the trial court found the school district did not present substantial evidence to establish a terroristic threat because there was no evidence that JS either intentionally or with reckless disregard threatened another student. The Commonwealth court affirmed on the basis of the trial court opinion. The case presents this court with the opportunity to examine whether JS's expulsion hearing complied with due process and whether the objective or subjective test is applicable, and under the test it's applicable, or whether it was met in determining whether the student's speech constitutes a true threat and thereby is not entitled to First Amendment protection. Interesting and complicated case. Mr. Hennessy, if I got close, please go ahead.
Thank you. May it please the court, Matthew Hennessy on behalf of Manheim Township School District. This is not a case about vulgar speech or political speech. Just weeks after the Parkland shooting, JS created a Snapchat message that stated, "I'm shooting up the school this week. I can't take it anymore. I'm done." The message had a clear nexus to the school. It was created by a student, sent to another student, used photographs of JS and a third student, and mentioned a violent act at the school. The board expelled JS, finding that his statement was a global threat directed at the school and that it caused a substantial disruption. The board's finding that statement caused a substantial disruption has not been appealed and is well supported by evidence in the record. The lower court reversed the board by deviating from the two-prong analysis used in JS versus Bethlehem. The court erred by holding that schools can only punish off-campus speech that is a true threat under Commonwealth versus Knox. Tinker versus Des Moines, however, holds that student speech is not protected by the First Amendment when it's likely to cause a substantial disruption at the school, which is what happened here. Therefore, a school can punish student speech if the speech has a nexus to the school and it's unprotected speech, such as a true threat, obscenity, or it causes or is likely to cause a substantial disruption at the school. That outcome is dictated by the special circumstances that apply to schools because of their important educational mission and need to provide a safe environment for learning. Forcing schools to meet the criminal standard in Knox during administrative hearings imposes significant burdens on schools that will hinder their ability to maintain and provide order in a school environment that's conducive to learning. The court also erred by concluding that JS was denied due process at his disciplinary hearing because the board lacked authority to subpoena the student that received his message, who I'll refer to as Student 1, as we have throughout the briefing. Administrative, go ahead.
I'm sorry, I thought you were finished. Go ahead.
No. I'm happy to answer any of your questions that you have.
Well, I just had a question about the substantial disruption argument that you're making. Wasn't the disruption largely caused by the school district's publication of the meme?
The school district did not actually publish the Snapchat image. It didn't send it to any students.
But it published that it published that there was an issue. It published what it viewed as the facts.
Well, the board notified, sent a district-wide email indicating to parents that there had been a threat, that they were addressing it, and that school was safe to attend. In other cases that have analyzed threats, they have found a substantial disruption based on administrative investigations, communications with parents. In many of those cases, there's no communication from the school district, but what happens is parents hear about it and they start calling into the school district, and now the school has to answer all these concerned parent phone calls and indicate what they're doing. Here,
Mr. Hennessy, this is Justice Doherty. Is it fair to say that the crux of your case and position is that JS made the threat against the school?
Yes, his threat was.
And it's fair to say, as I reviewed the evidence that was admitted in as exhibit number 1 dated 5/3/18, the actual Snapchats, taking in the words of my colleague Justice Weck, a contextual subjective analysis, it's fair to say that those photos, the essence of this case, really was a private communication in which JS was pretending to be student 2 and was mocking, for no better terms, student 2's infatuation with the rock band Cannibal Corpse, for which Cannibal Corpse has a song about tying everyone up and eating them alive. That in effect, the verses cited as you're arguing the violent text are actually lyrics from the Cannibal Corpse song. So starting from the premise that he threatened the school, share with me where you even come with that position with a pedestrian review of the exhibits introduced clearly show that he's pretending to be student 2, and at no time does JS make any overt threat, just repeating lyrics to a song by the Cannibal Corpse.
So I did not see any evidence in the record before the board that the statement made by JS was in fact a quote of a Cannibal Corpse song. The statement or the communication that he sent included his picture as well as the picture of student 2. There's been argument by his attorney that he wore Elton John type glasses. However, there's no mention of that during the hearing before the board. No description of them as Elton John type glasses except by his attorney. The fact that the attorney can offer an alternative explanation for the conduct doesn't make it a joke or any less serious, particularly where it's been circulated among students.
Does it make it a joke when it is a private, what I understand it's called a DM, a direct message, such that the conversation or the meme was passed from JS to student 1 only? It was student 1 who Snapchatted it or photographed it and dispensed it. Yet you did not move to suspend student 1 for the distribution as aiding and abetting this alleged terroristic threats, did you?
Student 1 was suspended for 3 days initially, along with student 2, whose picture was included in the communication and had nothing to do with it whatsoever. Student 1 was disciplined for his involvement. Additionally, go ahead.
Well, doesn't that just show Justice Doherty's point that your district's just trying to show that it's doing something? I mean, are you here before us today to tell us that what JS did was not making fun of student 2, mocking student 2? Isn't that pretty entirely obvious on this record?
I don't think it's obvious. I don't think the record is clear on that point. That's what he's argued. We believe that the evidence presented to the board could be taken differently that, you know, he could be making a true threat based on those statements. It's a very clear and direct statement.
He could be. He could be making a threat. I guess if you put on blinders and decided that was the outcome, he could be making a threat. In that circumstance of at least gray area, to be charitable from your perspective, wouldn't compulsory process be a bare minimum so that he could bring in a witness for cross before you expel him for out of school conduct, by the way, unlike Tinker?
In this case, the board didn't have the authority to issue a subpoena to compel student one to appear at the hearing, and the board tried to have student one appear at the hearing. They wanted student one to come to the hearing, but they were unable to obtain his voluntary attendance, and he refused to attend, and they were powerless to compel him to attend. So I still believe, the district still believes that the procedures under Pennsylvania's rules provide adequate due process at student disciplinary hearings because they allow the student to cross-examine the witnesses that are presented by the district, to present their own witnesses and evidence.
Okay, just one brief follow-up, and then I'll let you go. If, as you maintain, contrary to all the appearance in the record, this was a true threat rather than mocking, then isn't it interesting that nobody at the district thought for a moment to just call the police?
They did call the police. That was the first thing they did.
They called the police?
Yes.
Did the police
Absolutely.
come?
Yes, the police went.
Did the police go to JS's home?
Yes, an immediate investigation that night. That's why they were able to send an email in the morning and conduct school, albeit with additional police presence.
Mr. Hennessy is Chief Justice Barrett. I have to follow up on Justice Wex. The police at 11 o'clock at night went to JS's home, evidently, and I'm not sure it's in the record. JS said, you know, it was private Snapchat. I was just fooling around. The police reported to the schools at about 2 a.m. There's no true threat here. There's no problem. You can have school tomorrow. The school district ignored, well, they didn't ignore that because they had school, but they nevertheless proceeded, arguably inconsistent with the police's suggestion. There were no criminal charge for terroristic threats, which we all know is available. Rather, there was a school district charge. Now, is there anything inaccurate about that?
It's my understanding that there may have been a criminal charge for terroristic threats. I believe it was.
Is that in our record? Because I didn't see it.
I don't know that it's in the record. There's a news article that was, I believe one of the parties had admitted at the hearing that reference charges being filed.
Justice Donohue has a question, but before we do this, I appreciate we're pulling you all over the place. Can you just tell me really quickly, what are you arguing in front of us today? Are you arguing that a substantial disruption to the school justifies the suspension? Or are you arguing something else? Why should you prevail in the case?
A substantial disruption to the school supports the board's expulsion. And that's very clear under Tinker. Direct quote from the case: conduct by the student in class or out of it, which for any reason, whether it stems from time, place, or type of behavior, materially disrupts classwork or involves substantial disorder or invasion of the rights of others.
Justice Donohue, if I can ask one follow-up. The U.S. Supreme, and then I'm going to give it to Justice Donohue. I appreciate her forbearance here, her patience. The U.S. Supreme Court, I'm sure you know, just argued out of Pennsylvania, Manheim School District versus BL. Directly touches on the extent of Tinker when you have facts as we do here, off-school property, not school during school hours, et cetera, et cetera. Should we hold this case till after June when SCOTUS comes out with that decision?
I don't know what the SCOTUS decision will be. I know that they are discussing Tinker and how that applies. I will say that BL is different from this case because BL involves a case of vulgar speech. Right. Somebody used foul language, and here the speech is very different from that.
Thank you, Justice Donohue. Your floor.
There's too much of a lead up to this very mundane legal question. The amicus brief for the School Board Association makes a cogent argument that the school board has subpoena power. Yes or no?
I don't believe it does because the cases are very clear that for non-judicial bodies, subpoena authority needs to be granted by statute directly.
And they argue that it is, that the subpoena power appears in a different article of agency law, and they cite specifically the section 1128, authority to subpoena testimony.
That
if there's a legal question involved in this case, that's what it is. I mean, because the inability for a student who's going to be expelled to have the opportunity to present and cross-examine unwilling witnesses sticks out like a sore thumb in this case. So if you have the authority to subpoena, that would answer one of those questions.
I don't believe that the district has that authority, and that particular section that the brief was pointing to, I believe, has to do with employee hearings, not student disciplinary hearings. So to take from one section of the code and apply it to any other section of the code, I think would lead to odd results if that were applied uniformly throughout the school code.
Well, their argument is, and as I said, it struck me as a cogent argument, that section 1128 does not reference employees. It is a blanket reference to testimony.
Yeah, I don't agree.
I guess we'll have to look at it. I noted with interest that although you filed the brief after the amicus brief was filed, you didn't respond to that argument. So I guess we'll have to dive into that.
Counsel, this is Justice Doherty again. Do I understand your argument to be that under 22 PA Code 12.8 discussing hearings, expulsion hearings, that down at, I guess it would be under formal hearings 6, the student has the right to request that the witness appear in person and answer questions or be cross-examined? Is it your position that the witness that the student has the right to appear in question are only those witnesses that you choose to call?
The witness, as referenced in that section, is referring back to the prior section where it says that the district has to identify their witnesses. And the subsequent section says that they can make those witnesses appear and testify in person so that they can be cross-examined.
So when JS asked for student 1 to appear, your district's position was that it did not have the authority to require their appearance, correct?
Correct. That was the board's decision.
And yet, under the law, it specifically says education is a statutory right and the student shall, mandatory, be afforded due process if they are to be excluded from school. Now, it's not a violation of due process to call the main witness to the alleged actor that you want to expel, and how that's not a violation of that student's due process pursuant to a statute which specifically applies to student expulsion hearings.
The statute says that the student has a right to call their own witnesses and they have a right to cross-examine the witnesses. There's no reason for it to say the witnesses if it means any witness or a witness. The fact that it says the indicates that it's referring back to the previously referenced witnesses in the subsection above it.
But you're arguing, but I apologize. Isn't that contradicting your brief, which said the witnesses were only those witnesses that you chose to call? And since you did not call student 1, therefore they didn't have the right unless they chose to get student 1 on their own? Wasn't that the crux of your argument?
Student 1 wasn't identified by the school as a witness. He didn't appear as a witness.
And why not, if you suspended him for being involved in this act?
They tried. They wanted to get him, and the court in its decision below said that the school did everything it could, and there's really no challenge that there was anything it could have done more. That was the court's decision, that it lacked the power and there was nothing more it could have done.
But counsel, you relied on student 1's testimony affidavit. How is that not a witness?
They
That's
were
how you case by the testimony by way of affidavit.
There's no affidavit from student 1. There was investigations by the administration. There were the communications themselves. Student 1 doesn't need to testify to the communication because JS admitted he sent the communication.
But wasn't evidence presented, counsel, about what student 1 would say, or almost through the attorney rather than having him in person?
No, that was a discussion that was had prior to the hearing off to the side. It wasn't presented to the board about what student 1 would say. And in fact, if you look at the decision, there's lots of speculation about what student 1 may have said that would be favorable to JS, but not considering at all that he may have very well testified favorable to the board as well.
So how does that cause deterioration of student 1 without student 1 testifying? I'm really confused on that one. He was suspended, expelled from school for terrorizing student 1. Yet, how do we know that if student 1 didn't testify? The only statement was through a teacher.
JS was expelled for making a global terroristic threat directed at the school in general. He said, "I'm going to shoot up the school." The court only looked at the second part of the.
Now, can I interrupt you, Mr. Hennessy, because you opened with that in your first line, and I let it go. That's not my understanding of what JS said. What JS said, I think, was student 3. Let's call him. You have a student 2. So you have JS. You have the student that received the Snapchat, which is student 2. Then the student that the Snapchat concerned, which was student 3. Isn't it accurate that what the Snapchat said was student 3 with his long hair and, I don't know, his grungy look or his goth look, looked like a school shooter?
It didn't say that. That's what JS is arguing after the fact, claiming that he made a joke.
So tell me exactly what, and I can find it somewhere in this maze of notes, but what did the meme say? Not your characterization, but the meme itself. Snapchat.
The Snapchat message said, quote, "I'm shooting up the school this week. I can't take it anymore. I'm done." It also included an emoji of a gun and sinister smiley faces.
And did it have a picture? Was that a caption under a, let's say a comic, under a picture, and the picture was of student 2?
No, JS's face was on the bottom of the picture. Student 2's picture was at the top, and it was right over the middle of the picture.
What's the import of student 2's picture on there in the context of what JS intended? If you're correct, this was a direct threat by JS against the school.
It's not clear what student 2 was in there for. It's not explained in the message. JS said it was a joke. The board reviewing the evidence concluded.
Let me stop you again. A joke about a little, and you did charge him with cyberbullying. So a joke about student 2, or a joke about shooting up the school?
A joke about student 2 and shooting up the school.
All right. Thank you.
Let's clarify something, I think, Mr. Hennessy, because maybe I misheard you or you misinformed the court. Exhibit 1, dated 5/3/18, shows student 2 wearing his Cannibal Corps shirt, but it's shown backwards. And it looks as if he has the long hair and he's smiling, and it's under his name is, "I'm shooting up the school this week. I can't take it anymore. I'm done." It's a devil, a gun emoji, and a devil. And beneath that, there is JS with what appears to be round, big, circular glasses, red, similar to Elton John. And then there's Exhibit 3 of that same exhibit, in which it carries the lyrics showing student 2 citing the lyrics from Cannibal Corps about, "I'm going to take him alive and I'm going to tie him up and eat him." Now, that was DM'd from JS to student 1 when JS was pretending to be student 2. So going back to the original question, how is that terrorizing the school when it was a private means of JS making fun of the musical choice and the clothing of student 2?
The first exhibit that you referenced is the global terroristic threat. The second one that you referenced, including just student 2 appearing to sing or being present was not discovered by the school district until after they began their investigation the following day. JS didn't disclose it to the school board immediately. They found out, I believe, from student one. After they found out, they amended their charges to include the cyberbullying charge. The second message that you referenced is the basis for the cyberbullying charge, which is not on appeal in this case. The first message is the basis for the global terroristic threat, which is at issue in this case.
But you have
Just to clarify.
Yeah, I withdraw. Go ahead, Justice.
Just to clarify, the item, the exhibit that you're characterizing as a terroristic threat, how many people did JS disseminate that to?
JS sent that to student one. Student one made it public, which is a foreseeable thing to happen when you're dealing with social media on a platform that can be made public. And it was made public and viewed by other students. The student that reported it to the teacher received it from another student. He didn't actually receive it from student one. He got it from somebody else. So it circulated very quickly among the student body.
All right. And the trial judge here found that this whole scenario constituted a sophomoric joke. Do you want to explain to us why it could not be viewed that way?
6 weeks after, I believe, 17 students are shot in a major school shooting, this kind of communication can't be taken as a joke. The school has a duty to investigate this and to maintain order and an educational environment where students can feel safe and not worry about whether they're going to get shot up that day. And having these messages sent around among students undermines that the environment of the school.
Counsel, do you think the police took it as a joke?
I do not.
And would you agree that the police have more expertise dealing with true threats than school district?
The school district deals with true threats. The police deal with true threats as well, and they probably deal with it more.
Given the more than arguable basis for thinking this was buffoonery and teenage stupidity, why would we not hold that, as applied here, the law was unconstitutional in the absence of compulsory process? Wasn't the testimony of this witness critical for probing whether this was, as you say, a true threat?
No, I believe under the circumstances, because this is a school disciplinary hearing, that the objective test from Bethlehem works in this situation and provides the best way to analyze this. The court's decision in Knox never expressly overruled JS versus Bethlehem in the school context. It set forth the standard for criminalizing speech. But again, here we're dealing with a two-part analysis of whether it's protected at all, and then whether it causes a substantial disruption that allows the school to be able to punish the speech.
The counsel, following up on Justice Weck, the student one, the recipient of the Snapchat, who never testified, at the hearing, there was representations made that he and his parents were terrorized by this, but there was a hearsay objection to that, and it is blatant hearsay. I'm not positive what the school board did with the hearsay, but the trial court recognized that was hearsay. So assuming for a second that evidence is excluded, there is no evidence on this record that anybody was terrorized. There may be evidence, as you answered me earlier, of school disruption, but there's no evidence of terrorization, good evidence.
We believe that the school disruption is adequate to punish the student speech in this case.
Okay, fair enough.
Well, in that case, if disrupting the school is enough, then suppose this out-of-school social media tomfoolery, instead of this quoting of the Cannibal Corpse lyrics and making fun of a goth student, instead of that, it was JS went on and put out some ridiculous Snapchats about how the food in the cafeteria was gross and it was poison or some silliness like that, and that got Snapchatted around, why wouldn't that be sufficient disruption for you folks to expel him for that too? And if that's adequate, then where does this end? Wouldn't you be policing hundreds of students' social media accounts all day and all night?
So there's a couple points in response. One, the difference between saying that the food is gross and I'm going to shoot up the school is a very different statement. One is conceivably a joke, and the other is a very serious matter that's not a joking matter. Secondly, you mentioned about whether they're monitoring Snapchats. They weren't monitoring Snapchats. This came to the school by students. It was brought to their attention. So this isn't a question of the school going out and looking for these things. They only come when they get brought to the school's attention, which means they're only going to get brought to the school's attention if they're considered to be serious threats by people who receive them. Secondly, we have a situation, another example would be students who would be cheating off campus by writing a paper for another student, but doing it off campus, handing it to the other student off campus. Surely the school can punish that for undermining the educational integrity of the school. The fact that the two students cheating, one of them only does it off campus, wouldn't make them immune from punishment for that, because it does impact the school and the educational integrity of the school's mission.
May I follow up? Again, it strikes me, I think Justice Fleck intimated it, you're getting awfully close to being the thought police.
I'm sorry, I didn't hear that.
I said you're becoming close to being the thought police. Assume that, just hypothetically, JS sends this private direct message and student one never disseminates it. But somehow the administration finds out it might have been sent, subpoenas the Snapchat records and gets them. Do you see a distinction in those cases?
I do, because in this case, it was circulated among the student body, and that's what causes the substantial disruption, that many students learned about it and are then put in a position of having anxiety and fear about whether going to school is an appropriate thing to do for their own safety.
And that may be fair. Just to follow up, assume for a second that the school discovers this through that subpoena process or however, and immediately emails every parent and every student, no worries about this, it's not a true threat. You still have the same school disruption you have here. You merely have the school you merely are missing the link that the Snapchat story was online for 5 minutes and seen by 20 to 40 students, which are the facts here.
Well, in your scenario, the school actually would be the body disseminating the message. Whereas in this case, it was already disseminated and spreading. And so while only 20 to 40 people directly saw it, they sent it to other people as well. And we know that because the student who reported it to his father, who was a teacher, didn't see it on student one's Snapchat. He got it from somebody else. So they were forwarding it along. And so it's a very different scenario.
Counselor, it's Justice Donahue. You see no distinguishing point here that JS only disseminated that meme to one person.
No, I don't. And in fact,
why is that? Because go ahead.
The terroristic threat policy includes direct and indirect. And even in the case of Knox, this court found that Knox he created the video and sent it only to one person. That person posted it online. Knox didn't post it online. It's directly or indirectly. You can't protect yourself by sending it through another person.
That's your school district policy, because certainly in a broader legal context, JS's intent would have a lot to do with a determination of the speech that's involved here.
Other courts that have looked.
He clearly did not intend for this to be disseminated to anyone other than the person to whom he sent it. As a matter of fact, as soon as he found out it was disseminated, he insisted that it be removed from the shared platform.
I think the fact that he insisted it be removed from the shared platform indicates that he understood it was not a joking matter and that it would be taken seriously if it was seen by other people. And I also want to point the court to the case of, I believe it's DJM versus Hannibal School District, and that's an 8th Circuit decision where, again, it was a communication by one student to another. The second student alerted an adult and told them about the communications because they found them concerning. And in that case, the court found that intent was a factor, but it was satisfied by the fact that the communication was initially sent to the second individual. They distinguished it from a prior case where a student had made a statement or drawn pictures and made statements about, blowing up the school or whatever, but had left them in a notebook at their house that their little brother took to school 2 years later. In that case, there was no intent to communicate the message, whereas in DJM, the student clearly intended to communicate it to another, and the fact that that individual then relayed the information to an adult, a person, because they were concerned about it, didn't insulate the student from discipline.
Counsel, if it was a true threat, why would he rush to ask the other guy to take it down? Wouldn't he want to terrorize the whole school, like you said?
He may be worried about getting in trouble. He maybe change his mind. He clearly saw that people were going to be alarmed by this and wanted it taken down. It's an alarming statement to make, particularly 6 weeks after a school shooting, and after the school itself had dealt with an anonymous threat left in one of the bathrooms that they had just addressed with the school. So he understood that he could potentially face punishment for making such a threatening statement.
Mr. Hennessy, I know we're coming down the home stretch here, but it seems to me this punishment for the same act was incremental. First, they suspend him for 3 days. Then they suspend him for 7 days. And then they expel him. Why graduated punishment for the same conduct? So I understand the operative act is the expulsion. You're out of school. But it's the same conduct. So the first time they looked at it, they said 3 days. And somebody else took a look at it and said, well, let's make it an additional 7 days. And then the school board, I guess, or somebody took a look at it and said, let's do expulsion. It's the same conduct.
In the initial instance, they suspended all the students that were involved with the message until they could investigate it and find out what had happened. So JS was suspended initially, I think, for 2 or 3 days. Student 1 was suspended for 2 or 3 days. And student 2, who wasn't involved in making the messages or disseminating them at all, was also suspended for a couple days. As they investigated it, that's when they learned about the second message, which is the one, I'm going to tie him up and eat him. That's when they extended the suspension out to the longer time period, and then they did pursue expulsion after that.
Thank you.
All right, thank you very much, counsel. Just for the court, the next case that we're going to argue is a complex case with 3 lawyers, but we're going to conclude this argument, take a lunch break, and then hear the next case after lunch, which is a deviation from our pre-printed intent. Ms. McKinley.
Thank you, Your Honor. May it please the court, Lauren McKinley for JS. First, I just want to say I'm astonished that counsel does not know the facts of this case. JS was expelled based on both memes. The first meme, which is the funny picture of student 1 standing in front of the microphone under the light saying, I can't take any more, I'm shooting up the school this week, which clearly shows JS at the bottom as his own emoji. Underneath, there are at least 7 or 8 other emojis. They're all watching him. He's singing. The second one was a video meme, and there are a number of still shots from the meme in the record, but the charge against him was based on both of the memes, and the expulsion was based on both of them. And in fact, it's impossible under any type of contextual analysis to separate those things from one from the other because they both together provide context. You also can't take the words of a meme out of it and just say them out loud and say, that's what he said, that was a threat. That is not okay. That was not okay on the day that the board expelled JS because under this court's decision in JS versus Bethlehem, it was very clear that a contextual threat analysis was required whenever we have an expulsion based on an intentional threat provision, which we did here. So the district's argument that Knox and Howe changed that is just wrong. Knox may have changed the standard, the evidentiary standard, and that's something you will have to decide, but it doesn't matter because the board didn't do a contextual analysis at all. It used a words alone analysis that this court clearly said was unconstitutional because it violated the First Amendment. The other thing I'm just amazed about is not knowing that the school district lawyer stood up and made a speech before there was any testimony talking about how, well, student one isn't here. We don't have the right to subpoena him, but this is what he would say. And then he proceeded to produce the same thing from one of his witnesses. There was an objection, and then he said it again. So to say that, he said it, off the record in some little back room, that's just false. It's right in the transcript. You don't have to go very far to find it.
Ms. McKinley, Chief Justice Behr, I asked the other side about that. I understand what you're saying. However, that gets to intent. Because I think the terroristic threat requires that the student intended to terrorize another. However, that does not necessarily go to the disruption of the school. My recollection of the record is that there's no requirement that the JS intended to disrupt the school proceedings. Am I right or wrong?
Well, you're sort of right, I guess I would say, because substantial disruption is part of the Tinker analysis, which is an exception to the general First Amendment bedrock principle that students don't leave their First Amendment rights behind when they go into the schoolhouse gate. They certainly don't do that when they go home, which is what happened here. JS was at home. He was engaged in a private conversation with one other person. He did not publish it. He did not, it's undisputed, he didn't intend for it to be published. It was not intended as a threat. There's nothing about this speech that brings it into the schoolhouse gate. Substantial disruption can't be applied if Tinker can't be applied. Tinker is the foundational requirement, and the court spent 6 pages explaining why there was no nexus between the speech and the school that was created by JS. And neither this court in the other JS case, JS versus Bethlehem, or the Supreme Court have ever applied Tinker or the nexus or the substantial disruption test where there's no nexus created by the speaker.
What in your mind, Ms. McKinley, in your mind, what does that mean? I'm a little bit confused. Does that, and I did not go back and read the Tinker decision prior to, I'm familiar with it, obviously, we all are, but prior to this argument, and I did not go and read the briefs in Mahoney School District versus the Aplt. So again, I appreciate you've had the ability to concentrate on this case where I've concentrated on 10 of them. In terms of general disruption of the school under Tinker, does there have to be an intent or does there not have to be an intent?
Under Tinker, there does not have to be an intent, but Tinker doesn't apply unless there's a nexus between the speaker and the school that the speaker created. So for instance, if someone wrote an article and posted it in the New York Times and everybody's talking about it, it creates a disruption in the school can't punish that because it had nothing to do with the school. It wasn't brought into the school by the speaker. Here, the only person that brought the speech into the school was student one, and even that, first of all, this is the first time I've ever heard that he was ever disciplined, but second of all, he made a public post on his own Snapchat. He didn't call up the school and say, hey, I think JS made a threat. He didn't say anything. He just put it up because he thought it was funny. And then he took it down. He didn't do anything that a person would actually do if they thought someone just threatened to tie him up and eat him. It's ridiculous, and it's not supported by the evidence.
Counsel, this is Justice Doherty. The 2 questions granted. The first question is really a question regarding due process. The second is regarding student speech. The question or concern I have for you is, which one do you find to be paramount?
Well, I believe the due process is paramount because here we have a situation where the only evidence that's being used against JS was evidence by student one, who is the primary witness against him. That is who, that is, you know, what the charges are based on. Not only did the district not produce him, it didn't produce any statements. The record shows that student 1 was interviewed at least twice. Student 2 was also interviewed. The district did not produce any witness statements. Basically, this was an ambush. You know, we're not going to bring this witness. And by the way, we're going to use him as our star witness in absentia. You can't cross-examine him. That's basically what happened. This, in the last argument, someone mentioned something about the school district strategically failing to meet its burden of proof. That's what happened here.
Well, but Ms. McKinley, Chief Justice Berrigan, just to follow up on Justice Doherty's really thoughtful question, that's not a due process. You don't get to the constitutional argument unless you have to. I sort of see this case the way, arguendo, the way you see it. You grant the hearsay objection, you do one of two things as an appellate court. You reverse because the school district hasn't met its burden of proof absent the hearsay, or you remand this case and say, have another hearing and don't use hearsay evidence. And then I presume you prevail because at least on the terroristic threat, because they can't prove, putting aside subpoenas, they can't prove terroristic threat without hearsay. So do you agree that, you do agree that there's insufficient evidence of terroristic threats absent a hearsay? Is the remedy remand or reverse?
No, the remedy is reversal, because the board had the burden of proof. The board brought its expulsion charges against JS. It did not bring the evidence it needed to support those charges. We're 2 years out. JS is halfway through college. I mean, to remand would be absolutely ridiculous, and the board would not have jurisdiction because he's not a student. So remand it really is not an appropriate remedy. The point is, and this is another distinction between Tinker and this case, that, you know, the Tinker line of cases, the school speech cases, they're all direct challenges under the First Amendment. You know, school district, you know, the defendant, you can't punish me for this kind of speech. This is a due process case. This is brought under the due process clause. The district brought a charge under Pennsylvania law. They are required to prove the charge that they brought. This was a charge based on a terrorist threat provision that you're all familiar with because it's taken word for word from the Pennsylvania Crimes Code, which the district lawyer proudly said at the hearing. So you bring that charge and you don't prove it, you don't get to, on appeal, under a due process theory, bring in a different defense and say, oh, now it's a different paradigm. It's not a different paradigm. You brought a terroristic threat charge, you didn't prove it. That's it.
Ms. McKinley, let me interrupt you because you've said that 3 times, and let's say I agree with you. What I'm at a little bit of loss of, and I was when I read this record, is why do we ever get to due process? Why isn't this an easy case? The school district didn't prove their case. Sufficiency of the evidence, throw it out. And
I agree with you.
Because you know you don't get to constitutional issues unless you have to.
Right, I totally agree with that. The reason this aspect of due process, putting aside the aspect of burdens of proof, which is also obviously a very important due process issue, but the reason we got there is because the district put on the only evidence of intent the district presented was through student 1 who wasn't there. The only other evidence on the record of JS's intent came from JS and his parents. So basically what the trial court says, okay, well, if you're going to do that, you know, we've got a hearsay problem, and, you know, JS asked to have this person come and testify, and you said no.
Ms. McKinley, Justice Todd here. With all due regard and deference to the Chief Justice, I think I view it a little differently because I think the reason we took this case largely was to address the due process issue in the context of a school board expelling a student. And I thought the focus, I agree there's a sufficiency of the evidence, there's burden of proof in this case, But I think this question of what a school board can and cannot do before it punishes a student is a question of statewide importance and focuses on a due process analysis. So do you view the case the way I do, or do you just agree with Chief Justice Baer that it's really just a sufficiency of the evidence case?
Well, I guess I agree with both of you.
Oh, that's a great answer. That's a great answer.
Yeah, I mean, not to, you know, but
be running
really,
for office
what
today.
Right, exactly. But what I said to the trial court and to the Commonwealth Court, and I'll say to you too, is all of these things are important. You don't necessarily have to decide all of the issues in the case because we don't have the evidence to support the charge. However, I do agree with you that the due process issue with regard to the procedures is really critical. And the thing is, the procedures themselves are intended to effectuate due process. They're intended to implement the Supreme Court's decision in Goss versus Lopez. All of the elements in the procedures refer to different aspects of due process. The district does not get to pick and choose which ones it's going to honor. In fact, what the regulations say is that all of these must be observed in every formal hearing. I would like to say one thing about counsel's argument about witnesses, because I think in subsection 5 talks about witnesses against the student. That's referring to the witnesses against the student upon which the charges are based. The school district can't reduce the universe of witnesses upon, you know, that the student is allowed to use in their defense by simply keeping the most important witnesses off of their own witness list. That's not what due process means. All of those
by compounding that by presenting the witness through witness's testimony without the witness being there to be cross-examined.
Right, and that's why the court, you know, took such length or went to such lengths on the due process issue, because that's what happened. Even though, as I said, I don't think he actually had to do that. And that's the other thing about the BL case, and I'd like to just answer that question before someone asks it. That is, I don't think that this case needs to wait for the BL decision. First of all, the BL case, in BL, there's no due process issue. There's no burden of proof issue. It's just a question about whether off-campus speech in that particular context involving profanity can, you know, create the nexus to the school. We don't need to get there. The district court or the trial court didn't need to get there either. But the thing is, even if you did get there, even if you found somehow that this speech, which was intended as a joke, which is private, which JS didn't do anything at all to bring onto the campus itself, there's no substantial evidence as a matter of law. The court didn't have to decide that issue because it found there was no nexus. And since there was no nexus, Tinker didn't apply, and neither could the substantial evidence test.
Counsel, it's Justice Donahue. Let me ask you the same question that I asked your opposing counsel. The School Board Association was shocked to hear that school districts did not have the ability to subpoena witnesses in situations such as this. And they cited to Section 1128 of the Code in support of the proposition that they clearly have the ability to subpoena witnesses. Do you have a position on this, one way or another?
Well, I do. I guess the first thing I would say is I'm not going to argue with the Pennsylvania School Board Association about that particular thing. I don't know if they're right about that or not. I do agree with them on two very important points. One is, if we're construing the procedures to say that school boards don't have the authority, inherent authority, to observe all of the elements of due process in the regulations, we have a huge problem. I don't think that there is any justification for that kind of construction under the Statutory Construction Act, which, as the School Board Association said, would make the procedures unconstitutional. The other thing is, I think that the way that provision is placed in the public school code is a little confusing, although the language certainly supports its argument. But I think its historical argument was very interesting and very compelling, because in Pennsylvania, the right to due process in school expulsion cases goes all the way back to the 1880s, 1840s. Public education is so important. not just to the student, not just to the rest of the student's life.
Counsel,
but to the society
counsel,
as a whole.
counsel, this is Justice Doherty. Let me be very myopic on this. I believe opposing counsel was correct. I believe 1128 is specifically catered to tenured teachers. And that 12.8 is specifically guided towards the expulsion. It's a code in which under 12.8, it said the student shall be provided due process. It then provides that the student has the right to be represented with the names of witnesses against the students, copies of those statements and affidavits. Number 6, right thereafter says, then he has the right to request that the witness appear in person and never question. At no place in 12.8 does it indicate that the student or counsel for the student has the right to subpoena. The question I have for you is, why is this not a legislative fix as opposed to a judicial fix?
Well, I think it's because school districts always had the authority to do all of these things. And again, if you go back to why we have the procedures, which is to implement Goss versus Lopez. In Goss versus Lopez, we didn't even have an expulsion. We had suspension cases up to 10 days. And the court said there that the student has to be presented with evidence of the witnesses against him and an opportunity to respond to the witnesses. Testimony might not be the right word, but the witnesses' evidence, so to speak. And also may have the right to cross-examine in the case of a long suspension. Again, less than 10 days.
Counsel, isn't it?
We have all of these elements of due process, and we look at what it is that the regulations are intended to implement. It's not conceivable to suggest that the only witnesses the student has the right to call are the witnesses that the district is already calling, and so they have the right to cross-examine them, or witnesses they can get there by themselves. There will be no reason for 12.86, and we can't construe the regulations as if it doesn't exist.
Well, with respect to the construction council, why isn't this best construed as an as-applied challenge?
Yeah, I think you're right. I mean, I don't think that the trial court or the Commonwealth court really went as far as the district claims it did in saying, oh, the rules are unconstitutional, because they were very clear about, well, this is what the district told us, and if that's true, then yeah, that might be unconstitutional, who knows, but certainly with regard to JS it was, and this is why. And that's how we got into the whole issue about, calling, basically presenting student one in absentia. But I agree with you. I don't think that the court held the provisions to be unconstitutional, and I don't think that they are. I think when they're applied as a whole, which is how we need to do that, and due process is not a bunch of disparate things. It's a group of things that we need to observe fundamental fairness. And you can't just slice a few of them out here and there and say, okay, well, you got some of that. It's kind of like due process. No, that's not how it works.
Just to clarify, my question is, would you agree that in the event we agree with you, that it would suffice for adjudication purpose to hold that the application of the statute and rules here as applied was unconstitutional rather than a global invalidation of the statute? With
yes,
perhaps the forlorn hope that the General Assembly would come along and actually explicitly say you get compulsory process.
Yeah, I agree with you.
Counsel, Chief Justice Baer, just quickly, and obviously I'm going to have to go read Tinker throughout. I think your opposing counsel relied principally on the disruption of the school analysis. As I read the trial court opinion, and it was too long for me to find it during argument, I think the trial court said there had to be a true threat that causes the school disruption. Is your understanding, is that accurate, or can you have a unintentional statement cause school disruption and therefore justify suspension? or expulsion.
No, what the trial court did, the trial court applied Tinker first and said there's no nexus. Therefore, we can't get to substantial disruption. That's off the table. Then we look at whether there's a true threat. And at that point, he applied Knox. And by the way, he applied Knox because at oral argument, he asked the district's lawyer, do you think Knox is correctly decided? And is that what I should do? And they said yes. So, but it wouldn't have mattered because there was no contextual threat evaluation made by the board, and there had to be one. So there was no true threat. And the other thing is that he found that there was no objective evidence, or the memes were not objectively threatening. Those were his terms. So they couldn't, by definition, somehow, become school speech, even though they were made privately. All
right, Ms. McKinley, I'm still confused, and we're about ready to quit, so I'd like to not be confused coming out of this, like, can do that. In BL, the United States Supreme Court, I think, is going to decide the nexus question, the question after Tinker, whether or not this should be construed as on school property, or the like. Put that to a side for a second. Assume for a second that the U.S. Supreme Court says under BL, and by extension, in this case, this can be construed as on school property. What does that do to your argument?
It does nothing to my argument, because we shouldn't ever have to get to Tinker because the district didn't meet its burden of proof, number one. Number two, there is no due process issue in BL. There's no question about what happened.
Put aside due process for me, and just talking only about disruption of the school, not terroristic threats, not due process. And perhaps, well, I think you can do that. Would this, if this is deemed to be of school, within school, under Tinker BL, then what happens? What, again, without falling back to due process, terroristic threat, just on this argument, disruption of the school?
Well, I think that, first of all, I would be shocked. I mean, obviously, I can't speak for the Supreme Court, but the Supreme Court has never come close to saying that Tinker applies off campus when the student, by his own actions, has not created a nexus. And counsel mentioned the statement in Tinker about, oh, it's not just in the classroom. Well, right, but it's talking about the hallways, the cafeteria, the bathroom. It wasn't talking about when the student is in his own home speaking privately to another person. And the other thing about BL is, yes, I mean, her speech was made off campus and on the weekend and all that, but her audience was a lot bigger. So it was a very different situation than what we have here.
Ms. McKinley, and it's the last time I'm going to ask, and then we'll go research it and figure it out. You're arguing BL. You're arguing that if BL goes against you, it's wrongly decided. I accept all that, but I'm asking you again, if BL is decided against you and it's the law of the land, do you lose? And what you're saying was BL shouldn't be decided against me. I accept that, but maybe
No, I'm saying the answer is no. I should already have won the case before we get to Tinker. So that's right. My argument.
Thank you. Any other justices? Any questions whatsoever? All right. Again, thank you very much. Well presented. We'll take the case under advisement and let you know in a few months. What time is it? Oh, it's 12:04. Let's take a recess till 12:45. Is that sufficient for everyone? And come back and get 3 more cases to hear. All right. So we'll stand in recess for 42 minutes.
Thank you.